Welcome. This is the Domain Name Law Show. We're here every Tuesday. We just keep chugging along. Uh, Do this show every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts to this show. My name's Todd Ryan. My co-hosts are Jeff Newman and David Michaels. I'd like to get started by saying hello to my co-hosts, check their microphones and all that. Hey, Jeff, how's everything going with you today?
Oh, amazing. It's busy, man. Busy time, as you know. Um, Shout out to Todd working his ass off. Oh, am I supposed to say that language? Todd's, just so you guys know, Todd's working pretty hard. I'm working him hard. But yeah, we've been on, this is like our, what, third, fourth thing together today or something? Probably seeing way too much of each other.
Yeah, it's only noon here. Jeffrey stays up awful late some nights. So, yeah, 3 p.m. for him. But anyway, this is good, David, that you said, hey, let's make this domain name law show efficient. Let's make it 30 minutes and let's focus on the cases. And that's important because, today I was did watch some of the presentation that Nick Gardner gave. And right, it's tough when people listen to replays to want to listen to an hour of anything. So it is smart that we're doing this 30 minutes. We're going to jump in. But first, David, how's everything with you? What's going on?
All right, it's busy actually. A lot of things on the go, a lot of clients all of a sudden want to do trademarks, so things are good.
Okay. So busy times for all of us, and I appreciate both of you being here because I know you are busy. So we are going to do this all the time, everybody. Thanks for listening live. Thanks for listening to replay. You can listen to replays, YouTube, Spotify, and Apple Podcasts. So thanks for always sticking around. We appreciate it. Okay. So today we have three cases on the agenda, and if you want to check out our outline, you can go to dnlshow.com/outline and it gives you a link to the three cases that we're going to be discussing today. The very first case, the disputed domain name is cnainsurancecompany.com, and it's a unique case in that this domain was registered back in 2005, so been around for a long time, but yet CNA Insurance, this basically CNA Financial Corporation, this complainant filed this case. Obviously, this was recent, and after 20 years, finally went after this particular name and felt like they had a right to it. And our own Jeffrey Newman was the solo panelist in this case. So I'm just going to mention that the complainant was CNA Financial Corporation, who's on CNA.com. They registered that back in like 94, 95, but been around, even much longer than that, this insurance company. And I believe since 1964, but they're pretty much worldwide. But the complaint or the respondent in this case, the domain owner, was just Webmaster out of the UK, UK Domain Developers Limited. But Jeff, I wanted to say, okay, we've talked about it before, but as a panelist, when you are assigned, I mean, the forum assigns you to be the panelist. Do they first ask you, are you any conflicts with the complainant or the respondent? And is that before you get the complaint? Tell us how it all works and the complaint, and then basically just take us through your process here.
So WIPO and the forum actually do this differently. WIPO, yes, WIPO sends the panelist an email with a form. The email says the case that they're thinking of appointing you to is whatever it is, and they list the parties and they list the attorneys for the parties, and then they say, do you believe you have a conflict? Please fill out this form. And on the form, you indicate, no, I have no conflicts, and I'm going to, I want to hear the case. Or, no, I have no conflicts, but have no time. Or, yes, I have conflicts and I can't hear the case. The forum just sends the case, says, thank you for agreeing. And it's really upon the panelists to say whether or not we think there is a conflict. And so I always send back an email saying, one confirming receipt, letting them know I got it, and then letting them know that there is not a conflict. I have not yet had a conflict with a forum case, but But yeah, so the forum just assumes you're not conflicted and just sends you the case.
Okay, so no, it's good to know because I always hear panelists talk about is there a conflict and how do they let the service provider know. So WIPO asks, and the forum just assumes. I mean, I guess just guesses that you'll inform them if you are. So in this case, this company, CNA Financial, what was the give us the facts basically of their complaint and why they felt like they wanted to file this UDRP after this many years, and why they had a right to the name after this many years.
Yeah, so look, it as I think we've talked about before, trademark owners monitor their mark in all sorts of places. Um, and there's lots of names out there that people have registered that they could go after, but they can't go after every single name. It's kind of like a whack-a-mole game, and you'll never get all of them, even if you tried, and you're just going to spend a ton of money. So this name from 2005 until this case, or until 2025, was pretty much inactive. There was nothing on the website. There was no evidence of any use at all. There were never any complaints. And so, why spend the money to go after it? Just doesn't make sense. Again, there's probably 1,000 names like this with CNA that they could go after. But this trademark owner, like many, are making choices and they're going after names that really can hurt them. So in 2025, someone started using it. Someone put content up on the site. Someone activated MX records, and they thought, okay, well, now this one is more of a threat, and now we're going to go after them. And that's what they did. So, you know, trademark owners, like everybody else, have to make choices. And although it's been 20 years that this same registrant perhaps has had the name, that doesn't give them any, right to it. There's no latches defense um, in under trademark law, which in courts, what latches means is, look, you knew about this 20 years ago. You've done nothing. I've relied on the fact that you've done nothing, and therefore you should, you can't go after this name. That applies in US courts, doesn't apply in UDRP cases. Plus, even if it did apply, well, there was no response by the respondent, but it would be hard pressed for the respondent to say that they relied on having this name for 20 years when they never used it. Um, so, look, this is one of those cases you see the name, you're like, okay, you see the name first before you see when it's used. And it's one that you just kind of first think, how could anybody justify using, it wasn't just CNA.com, which obviously is taken. And it wasn't just, CNA sucks or CNA is great or anything like that, which arguments can be made that, in theory by a respondent as to why it selected it. But when you do CNAfinancialcompany.com, it's a pretty clear case of cyber squatting. Um, or I should say, it creates a burden on the respondent to really have some justifiable reason. So, but I think why this case is interesting is really, I kind of went into, there's a lot of decisions, and one I think we're going to talk about a little bit later, where they go into the impact of having MX records in the domain. And there's a lot of cases that'll say, well, they have an MX record, they're probably going to use it for phishing. And I never like to assume that, right? Number one is I always want to verify that there truly is an MX record. And number two is, okay, I got to look at all the other factors, because my view is that having an MX record alone is not going to establish bad faith. But having an MX record combined with having a site that has insurance related materials, or at least at one point had it on there, and then, using such a famous name or an obvious name with no explanation, it's really the totality of circumstances that, made it a clear cut case. So, yeah, I mean, Curious to know what you guys thought of it.
Yeah, David, what did you think looking at Jeff's summary and decision around the case? CNAinsurancecompany.com is the domain name. I can think of one way that the domain owner may have had a defense here, but David, what did you think reading Jeff's decision and summary of the case?
Well, I don't think Jeff is wrong. When I first saw the name, I thought it was a spammy name because it's got 3 words in there, right? You can't really have a professional company with 3 words in there. CNAinsurancecompany.com. I came across an email that came in my inbox. Actually, it was my spam folder the other day. It was Google Assistant Privacy Litigation.com or something like that. I posted a screenshot on X about it. Anyway, I first thought, that's a 4-word, really long domain name. Nobody's typing that in. So that must be like phishing. But then I Googled it without clicking on the link. And yes, there is privacy litigation. There is a deadline to, submit your evidence of, you purchased a Google product in the last 10 years, and you get money because there's a $68 million settlement. Unfortunately, it requires you to have the serial number of the device and the receipt. And for me to do that, that'd be a lot of digging to find stuff from, more than 6 years ago. Because I haven't bought a phone in the US in more than 6 years. So that's an issue. But yeah, and the other thing was I wasn't clear that who was going to be the complaint when I first saw this name. I thought it was going to be Cigna because when I see CNA, I think Cigna because I'm very familiar with Cigna. It's very popular, and but I did my research, and it turns out that CNA Insurance is an amalgamation of a couple other insurance companies. They're in the commercial field, and I just never come across them because I'm not in that field, and I just never had a use for commercial insurance in the U.S. But it's interesting. I did an open corporate search, and there was a CNA Insurance Company Limited incorporated in the UK where this respondent is located. And I was wondering, okay, well, maybe it was a legitimate business before, or is that a branch of the US business? I don't know. Because there's also for Europe, there's several of these companies. I think there were 18 of them I found. But there's over 3,000 businesses with the name CNA, so that's not distinctive by itself. But combining with CNA Insurance, I can see the argument. I see the case. Looking at the security trails, history of the DNS and the A record and the MX records. It was parked at ParkLogic from 2017 until when is that? It looks like 2021, and then he switched to Parking Crew, and then he switched to something else. Although it looked like it went expired for a little bit, and then it switched to something else, which is new hosting. So I don't know if you bought it on expiry auction recently, or if this is the original registrant. So that's an interesting issue. But I can't see anybody typing in this long name. Like, I don't know how you would have earned any money on this domain name through parking. So the logic is, is there MX records? Well, yeah, there have been since like at least 2012, but they've changed over the years. There's only been A records so there's been A records since 2008. So there's a lot of history with this domain name. It's gone through a lot of things, but I don't think there was any malicious stuff going on while it's parked at ParkLogic, other than ParkLogic doing zero-click ads, which I don't like. So who
Okay.
knows?
Well,
But I think that I would have issued a transfer in this case, knowing what I know now. But when I first saw it, I was like, oh, what kind of claim is this? So you
Well,
really have to dig
yeah,
into this sometimes.
and if they just had CNA insurance, there's theoretical, uses, but CNA insurance company to me was like, okay, now it's the entity itself, or they're targeting the entity. And the only reason, like I said, to think of is why to have a name like this. I don't know why anyone would do that, register it, but yeah, this day and age is probably could be used at some point. But like I said in the decision, I'm not just going to make that assumption that just because there's an MX record, but combined with everything else, I have heard of CNA because for several companies I worked for, and I managed their insurance risk, legal stuff, and so CNA was someone I frequently came across. Um, and that, I guess, that's an interesting issue. We've talked about it before. It depends on the panelist, right? So I'm a U.S. panelist, and I've heard of CNA. If David were a panelist, or there's a panelist in Canada, they may have never heard of them, and they wouldn't have, made the assumption I did when I first got it. It's about perspective.
Yeah, well, actually, I looked them up. I Googled them. They actually do have offices in Canada, so they do operate in Canada under cnainsurance.ca. It's interesting that there is also CNA Insurance Sucks.claims, which is, I don't know how much that TLB costs to renew, but it's being renewed. And then there's CNA Insurance TX.com. CNA Insurance-SharePoint.com is an active site, and it's registered in 7 TLDs. So this company really needs to clean up this stuff. I understand that there are brand protection companies now that are using tools to uncover these hidden domain names that before they were oblivious to. So, we'll probably see a few more of these UDRPs from CNA coming soon. But I really wonder, Todd, do you know how much they pay for CNA.com? Because I can't imagine that they were the original registrant of CNA.com. That seems like an investor name from 1992 or something.
Possibly, but yeah,
Yeah.
I don't know. There were 3-letter domains available to register even past '94 when this one was registered. So I know I can't remember when the last 3-letter. Of course, these are good letters. The last 3-letter .com was registered, but I believe it was even up to the end, towards the end of the '90s. And for some of the not great letters. Now, you guys, okay, so Jeff ruled in this case to transfer the domain name as the panelist. David, even with a different perspective, says, yes, I would have transferred it as well. And the interesting thing about this case is, so looking at it, okay, so this complainant's on CNA.com. They're a financial company. They offer insurance. This is CNAinsuranceCompany.com. Seems awful fishy. Jeff didn't jump to any conclusions, basically looked at the evidence. But as we know, when a respondent doesn't respond, it's well known. It's well known in a UDRP that it's basically written in the rules that a complainant can make a prima facie case. And what I mean is they're going to lay out their case. And if a respondent doesn't reply, and we've went over this many times in here, that the panelist is allowed to look at, and Jeff did exactly that, the totality of the circumstances, all of the evidence. And he didn't say, hey, these MX records show that there was some phishing. He says that in addition to all the other evidence, supports an inference of bad faith. And without a response, it's really a smart decision by this panelist. Okay, so I said that Jeff was smart here, but it's exactly what you want. So it didn't already put his finger on the scale just because, hey, CNA Insurance Company, they're obviously in the wrong. Because if this respondent would have responded back and said, well, I was preparing to be a representative for that company, and here's information that I had, although it didn't work out, or I did have an agreement with them, or I was planning on starting a company called Canadian National Association Insurance Company. If he had a reasonable and real explanation, there could have been a defense here. But I agree, because I always used to think panelists, when it's a no response, where they do have to look at all the evidence that's submitted, and usually some complainants like this one, we're just saying, hey, we believe that there's some phishing going on, but also what is the reason for owning this name, and these park pages don't help. So it's not as easy a decision as you think. So anyway, this ended up being a transfer. CNA Insurance Company was transferred to the complainant. This next case, and David, I think Jeff and I are going to need your help on these next two, although I've looked at them, but because we were so busy today that I didn't brush up. But I love this next case. The disputed domain name is slurpbee.com. And I say SLURPBEE. So yeah, you can imagine who who's the complainant in this case? You're right, 7-Eleven. So 7-Eleven created this Slurpee. They see this person in Colorado in the U.S. Domain registrant owns a registered Slurp B, and they also registered BEESIP, like B SIP. I don't know, but this complainant, 7-Eleven says, "Hey, we're Slurpee. We're big. We got." I was looking at this and I was thinking, how many? They had like 84,000 locations in 20 countries. Man. Okay. So obviously everyone's heard of a Slurpee. They have a trademark for it. So that qualified them to, file this UDRP. Basically, they had standing, and the panelist, David Bernstein, was it David Bernstein? Yeah. He said, yeah, so you got standing. And then he went into, all right, well, this respondent actually responded. So he was saying, so tell me, why'd you get this? And the respondent said, oh, I didn't target them. I was going to do my own product. And I also registered B-SIP, sounds like a beverage. And the respondent did answer and thought he had a sufficient answer by saying, I was going to do my own thing with this. Well, I'm not going to give it away just yet because I have more to say. But David, let me go to you first and tell us some facts of, how did the respondent respond here? Do you think he had a good defense of why he registered the name? And then Jeff, jump in after that and I'll finish it off. Go ahead, Dave.
So the respondent tried to respond, and I'm glad he did. He did say that the MX records being something nefarious is speculative. I would have gone further and said, like, it's absolutely, slanderous or libelous to write something like that in a complaint. But beyond that, the name Slurp starts with there's over 1,000 domain names that start with the letters SLURP. Slurp bowl, slurper bowl, slurp ramen, slurper doodle. There's all kinds of stuff out there. This guy, I Googled him. He lives in Colorado. He seems to have been involved in a GS4 security case. I think he was a witness for GS4. He's in his mid 30s. I don't really see him as being a nefarious type of person. However, um, I don't think he understood the implications of creating a beverage to start with the word Slurpee, or sounds like that when you have Slurp B and Slurp P. Some people think in exactness, and it's a different mentality than the American mentality where confusingly similar is like blurs everything. And so I think he's Northern European. I don't know what kind, either Russian or Norwegian or whatever. It doesn't matter. The point is, some people just have a different mentality and they believe in exactness. And if there's a little bit of difference, they notice the difference because they're so attuned to that. That's why their names are so long often. But anyway, so in this particular case, he didn't realize that there is a confusing similarity, even if he did launch a product, which he didn't. All he showed was a logo that he generated with ChatGPT when he registered the domain name, but he never published anything. And David Bernstein wasn't satisfied that this respondent took sufficient steps to build a business that would dissuade him that there is any type of confusing similarity or some type of attempt to confuse. I don't know anybody who goes to slurpee.com. Is that even a site that's active? You know what I mean? Like, so have you ever thought of going to slurpee.com, Todd?
No, I was about ready to check it out, but you're right when it comes to, you don't go to Slurpee and go, I think I'm going to order one, but that's not the point when it comes to, when it's just basically deciding whether it's confusingly similar as a drink, Slurp B. And you're right, David, in other countries it's different, but here in the U.S., to have a drink there's a trademark for a drink called Slurpee, and then you're going to call yours Slurp B. Well, certainly in a court, the 7-Eleven would have a strong case, but we're talking about the UDRP here, and David Bernstein felt like, well, Jeff, I'll send it to you, but he felt like, did the guy make a bona fide use of the thing? What efforts did he make to really turn it into a real company anyway, or was he just talking? We don't know if we can trust the guy. He answered, but he didn't make any effort to really turn it into a product. Go ahead, Jeff.
Yeah, this is a case where it's so typical of Bernstein too. He changed the burden. He put the burden on the complainant to establish a good faith reason as to why he registered that mark. He basically said, now look, he didn't provide, like he provided me or us, the panel, with a good reason as to why he liked the B part of it, BEE, because there was, a hive mind or some B kind of aspect with it or to it, but he didn't really respond to the why the slurp part. And again, that just it puts the burden on the the respondent, which is not really where it belongs in a UDRP. It's supposed to be the complainant proving that there was bad faith. Um, and so, David says, well, the mark, essentially, the panelist says the mark's famous. He obviously knew about the mark when he registered it, hasn't offered a good reason as to why he registered it, and therefore we're just going to assume bad faith. Um, I would not necessarily have done that. Again, I haven't seen all the evidence here, but because there was a response, there were receipts, and there were other things that were supplied. It's one of those cases where it's not clear cut, and in fact, it's one of the few cases that applies trademark dilution, which is a trademark principle of essentially blurring or hurting the reputation of a famous mark um, without, but normally dilution is like I said, it's a court principle. It's witnesses and cross-examination, depositions, all that kind of thing. So, David likes to decide these cases. He believes that panelists should decide every case no matter what. Whereas I might have taken this case and said, you know what, this can't be decided on the limited stuff we have here. And so, we think it should be dismissed. But he went all the way, found that it was bad faith, and ordered the transfer.
Yeah. So, I mean, like you mentioned, so deciding when you say, I believe you registered it in bad faith, and the respondent says, no, I didn't. And then David says, well, I really don't believe you. I mean, the right reason I don't believe you is because, and I think David has good right to say, well, you didn't really, we know with in the UDRP, you have to show that you've demonstrated an effort to turn this into a product or a business, and all you have is this logo that AI created. So I just don't believe you. But and when there's no response, then it's really tough to say, um, you know, then it's really tough to know for a fact what was in the mind of the domain owner when they registered this name. When they don't respond, then many times the panelists will make the leap and say, we believe that you did it in bad faith. We didn't get a response from you. And that we're looking at the complaint, and they've made like I said, they've made a case against you. We need your response. In this case, the guy did respond, tried to be clear and say, I think what his fault was, he really didn't build anything. And two, he was going to do a drink on Slurp B. And when you're going to do, something against a pretty well-known trademark, you need to have your ducks really in a row. And it was a benefit to him to get David Bernstein as a panelist, but this wasn't a surprising ruling to me, because I looked at it, I think all panelists, well, I can't say all, but most of them do think, all right, what you said you were going to make this into a product or a business or a service or something, but what did you do to do that? And they want to see that you've, incorporated. They want to see that you've, spent money. Basically, there's, significant things done in an effort to use this in a bona fide way. But anyway, so this was a transfer. Slurp B, SLURP BEE was transferred away. We'll go to our next case just so we can try to get out of here. It's already been 30 minutes. Try to get out of here on time. But so those first two cases, CNAinsurancecompany.com was a transfer. Slurp B was a transfer. Okay. You got this Jeff Newman and you got this David Bernstein. And then, and then there's a couple transfers of completely different cases. The third case we're going to get to is CaseTrack, CaseTrack.com. Interesting about this is, as a domain investor, if you saw this on a drop, you'd think, CaseTrack, I don't know, I'll spend a little bit of money on that name. Just two words that, anyways, they do go together. So the complainant in this case, CaseTrack, was Stephen Alexander, doing business, DASRFP, doing business as CaseTrack. Okay. He was internally represented, and John Barry Hill always jokes around when he sees that and says, what, by your liver? Okay. So the respondent was DM Precise Media, represented by Berkeley Law, PA, United States. Okay. Anyway, so the factual background, the complainant is in the business of providing software as a service, medical, it's like Medicaid billing. So you can imagine CaseTrack sounds pretty descriptive. And, well, and I was going to say, was this a 3-member panel? Yeah, no, it was just Evan Brown. But he felt the same thing, that this is pretty descriptive. You better have a pretty good, response here if you think you have you better have a pretty good complaint, because it's pretty generic. And the respondent did respond and basically said these are two English words. But before some other facts of the case, David, let me throw it to you. What did you see when you saw this case and when you first thought CaseTrack, this company is trying to claim, make a claim to these two, generic words, CaseTrack.com? Did you think they had a chance, the complainant, when you saw this case? And what were your thoughts?
No, I didn't think they had a chance. I didn't know they could trademark a name like CaseTrack. So, actually, I saw this name 6 years ago and I wanted it because I had a Lexus subscription and I wanted to track cases and build my own platform because it's like a really profitable business. So, anyways, I couldn't get it. It was like on the aftermarket, I guess, or something. I don't know at that point. But this complainant, the DASRFP, filed a trade name registration in 2023 for CaseTrack, but he didn't submit that to his complaint. Apparently, it's missing for the paperwork, and he actually got his trademark registered a couple of months ago. It says registration date here is April 7th, 2026, but that does not predate the acquisition of the domain name. So right there, he loses. He tried to show, oh, we had common law rights to the name before, and here's an invoice for $5,200. And it turns out that that company is actually owned by his wife. So that's an internal transfer. DAS RFP didn't actually use the name CaseTrack in commerce at all. He claimed to have in his complaint. He said so in his USPTO application that he had been using it in commerce since July 2019. Well, that's a false statement. And that is a cause to even get this trademark registered, like that's registered, to be canceled. And if I were the owner of CaseTrack.com, that's the first thing I would be doing now. I would be filing cancellation proceeding against this trademark registration for making a false statement in the application. It is registered, oddly enough, for software as a service featuring software for medical aid billing compliance and automated documentation validation. So it's in the medical industry. But if you Google this company, DAS RFP, they were doing proposals for antenna installations. So they've been all over the map with this particular company. And the respondent, if you go to the domain name, it has a landing page with a login, and it says, enter your login to track your legal cases. So nothing to do with medical. And you know what? It's just merely descriptive for anything. So I don't know how he got it registered, but he did. And it's on the principal register. So it happens.
I'd like to do a TV show, David. It's like a trademark. I'm the trademark office, and you come wandering in, and I'm like, it's you again, huh? What are you going to, you're filing it to cancel another trademark? and it's like at a post office, and you're like, anyway, we know David's always willing to. They better cancel that one. Anyway, I like that you bring that up, David. It made me think that the panelist here should have at least considered reverse domain name hijacking, because he said, no, this isn't worthy of saying that they're abusing the system, when I in fact think they did. So Jeff, jumping to you, Evan Brown was a solo panelist here. This person, David mentioned, they say, we had this common law trademark. Look, here's a receipt. And it was their wife spending $5,000 5 years ago. And they're trying to throw that as a receipt to say, look, we were doing business back in the day. It's good that they found that out, that it was his wife. Obviously worthless. But so that in itself, knowing that he's supplying evidence like that, it makes me think, yeah, and you're really abusing the system. But Evan didn't think so. What were your thoughts on this decision by Evan Brown?
Yeah, it's interesting because they do have a registration, so they should have been given standing unless they didn't mention their registration at all. Yeah, they would have lost anyway because of the dates, but did they not mention it in the application or they mentioned it was an application but didn't mention it was a registration? And maybe that was a timing. I don't know when this was filed.
It's
But
a timing issue. So the case was filed in January and the registration happened in April. So a few months went by.
the case was filed in January, and what's the date of the decision?
Let's see. It's March 12th.
Oh, okay, so it's an older case. All right, I didn't know, Todd, you reached back. Okay, yeah. So if the trademark registration had issued, obviously there would have been standing. Now I understand. But yeah, you got to have some good evidence of common law usage, more than a invoice to your wife. And what did they say? There was some Google document or something found in Google that dated back to 2018, but it was really nothing. So I mean, the decision was right. Um, I don't know if the complainant asked for RDNH, but if they did, then yeah, it seems like it would be something for RDNH, but they didn't find it. So, and I don't know if it was asked for. If it was, do you know, David?
It was definitely asked for.
Yeah.
Yes.
Oh, it was asked for, and Evan he didn't address it, or just.
He did. He says that in the present case, the panel has concluded that although the complainant failed to establish the trademark rights, the threshold of trademark rights, and did not provide any evidence to support bad faith registration and use, a finding of reverse domain name hijacking is not warranted, particularly since the complaint is proceeding on a pro se basis. So if this was filed by an attorney,
Oh, definitely,
then
yeah.
we would have, yeah. And that would have been probably forwarded to the state bar in some states, depending on how they handle those things. But that's what I think should be a practice.
Yeah. So, I mean, I understand there's lots of attorneys that are not likely to find it against individuals that file, but while I understand that to an extent, it really also should, if it's this devoid of information, you still should send a signal that this is not the type of thing that should be filed. Um, if it was just that they couldn't show common law rights, but they showed some usage, and they showed they made an effort to show bad faith, and then maybe not. But since they didn't make that effort, I probably would have found that domain name hijacking, reverse domain name hijacking. Sorry.
Yeah, and Jeff, you're right.
And they would do that today also if there was a new complaint filed, because there are 101 domain names that start with the term case track. A lot of them, like casetrack.app, casetracker.com. There's so many generic uses of this name. Go ahead.
Todd, that was you.
Yeah, I was looking at casetrack.net, which I think that is the complainant's website. But Jeff, I was going to say the Evan Brown, this panelist was very understanding, saying, okay, so this was an individual trying to protect his mark. even though it didn't seem like a very strong case he made about his common law, but he was very understanding and said, okay, this person probably didn't know, was out there trying to protect themselves, so I'm not going to, slap their hands too hard. But I agree, Jeff, they could have put in the summary, I want to be clear, although I'm not ruling RD&H in this case because the person represented themselves and we don't see the full complaint. It maybe appealed to the panelist in some way that should have been clear and said there's several reasons why this shouldn't have been filed, even though I'm not going to rule an RD&H. But anyway, so it was ruled a complaint denied. The domain owner gets to keep the domain name, and it is a pretty good domain name. And I must have reached back when I was looking through WIPO cases, why I was looking for ones with a couple generic words, and I found this one and didn't realize it went back to March, the golden days, about 3 or 4 months ago. All right, that's going to do it for today's show. Next week, we're going to be here. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Try to get done in 30 to 40 minutes, which we did pretty close today. Thanks for listening on replays. Thanks for joining us live. And if you want to talk domain name investing, that's an open forum, open stage, open discussion. Come back here to X on Thursday at 10 a.m. Pacific, 1 p.m. Eastern. We got the DNX show, and we talk all things domain name investing related. It gets pretty hairy in there, but anyway, we're going to offer all sorts of strategies this week on how you can make money from investing in domain names. Thanks again for joining us, and take care of yourself wherever you're at, and we'll see you next week.